Welcome back, everyone, to AJ 101 Criminal Law Online. And tonight's going to be the Chapter 7 lecture on laws of arrest. Now, this is a pretty long chapter. I haven't really figured out if I'm going to kind of divide it into two lectures or one. I'll try to keep it under one. But again, there's a lot of ground to cover here. So this will be one of those chapters where I really need you to help me, which means that you need to read the chapter, the textbook, so you can have a good understanding of what it is that I'm going through and I'm talking about, because I'm going to kind of go through this pretty quick in order to be able to fit it all in. Okay, so laws of arrest. So where do we start? Well, let's start with the definition of an arrest. What is it? Penal Code 834 defines an arrest as follows. So an arrest is taking a person into custody in a case and in a manner authorized by law. An arrest may be made by a peace officer or a private person, and we'll talk a little bit more about that later on. Now, Penal Code 835 defines actually how an arrest can be made. So when you look at that, an arrest can be made by actual restraint or submission into custody, meaning like, hey, you're under arrest, turn around, put your hands behind your back, or where we see a lot of things now and a lot of controversy throughout law enforcement and on TV and the media and all the kinds of things like that would be where the officer may use what is called reasonable force in order to effect an arrest. And law enforcement officers have the right, okay, not only to overcome the resistance of an attacker, but they also have that right to use reasonable force to effect an arrest. The issue really surrounds the word reasonable and what really is that. And we'll talk a little bit more about that kind of later on. So how do arrests usually happen? I mean, and why do they happen? Well, we know that they happen because of violations of laws and things like that. But we also have these things called encounters and detentions. Now, there's a legal difference as to what actually constitutes an arrest and what amounts to a temporary detention for questioning. And there are obviously innumerable contacts between police and citizens that do not amount to arrest. Now, the California courts have recognized and distinguished between these situations as kind of cited in the following case. So there are many contacts between police and citizens which are in no way related to crime, but from which evidence of a crime may result. They arise from the police officer's duty to maintain peace and security, to protect citizens from harm or annoyance, and to do all of those innumerable miscellaneous tasks which society calls upon the police to perform, which honestly doesn't have a lot to do with the detection of crime. Now, such contacts are not governed by the statutory rules of arrest, but they are governed by the Fourth Amendment requirement that government, including police, search or seize activity must not be unreasonable. So when an officer takes action which amounts to a seizure of an individual, detention, or an arrest, the Fourth Amendment safeguards come into play, and we'll talk a little bit more about that as we kind of go on in the chapter. So even when an officer acts for the sole or primary purpose of uncovering or investigating criminal activity, such actions are not subject to the Fourth Amendment unless they amount to some sort of search or seizure. To determine whether a contact between an officer and a person amounts to a Fourth Amendment seizure, if you will, it's necessary to kind of look at the United States Supreme Court definitions on what those are. So I'm going to kind of tell you what those are very quickly. A search occurs when governmental action infringes an expectation of privacy that society is prepared to consider reasonable. A search also occurs whenever government officials physically intrude on things listed in the Fourth Amendment: persons, houses, papers, and effects, and we'll talk more about that later. A seizure of property occurs, excuse me, when there is some meaningful inference by the government with an individual's possessory interests in that property, and a person has been seized within the meaning of the Fourth Amendment where the government, by show of force or other assertion or assertion of official authority, communicates to an individual that he or she is not free to leave or disregard the police presence and go about their business. And there's a couple cases excuse me, that go along with that. So wow, given this definition of what what is a seizure, what is not a seizure, what's a person, all those other things, let's talk about police contacts with citizens and how they can be categorized in the following three ways. The first one would be consensual encounters, and this is a contact that really requires no legal standard of suspicion. So you're walking on the street, I walk up to you and say, hey, how's it going today? Got a minute? Mind if I talk to you? And we're just having a conversation. You are free to leave at any time, and I'm just talking to you. That's a consensual encounter, and there is no legal standard of suspicion. I can do that just to do that. A detention is the next level, and it's a little bit more. As you'll see, this is a seizure, if you will, under the Fourth Amendment, and requires a minimum of reasonable suspicion. That reasonable suspicion being that maybe I believe that you might be involved in some type of criminal activity, and I have reasonable suspicion to believe that. Therefore, I want to stop and investigate that a little bit further. And then finally, arrest. This is also a seizure under the Fourth Amendment and requires a minimum legal standard of probable cause. Probable cause to believe that you were involved in this particular type of crime, and therefore I am going to make an arrest. So let me kind of elaborate just a little bit more. So consensual encounters, I kind of touched on that, but typical examples that require, again, no justification: an officer walking up to a pedestrian and requesting, not demanding, to see some kind of identification. Officers asking a person if they would mind stepping aside and answering a few questions. Officers approaching the occupants of a parked car and engaging in conversation. And even a knock and talk at a residence, in the doorway, talking to people at a home. Those are considered consensual encounters. An encounter is also still considered to be consensual even though the officer may be in uniform and driving a marked patrol car, as long as no force, commands, or other manifestations of official authority are used to require the contacted person to basically remain there. Okay, so there's that. So that's kind of the in a nutshell, consensual encounters. Now, detentions, under, for like temporary detentions, the two most common examples of temporary detentions are the pedestrian stop and the traffic stop, honestly. That would be for a traffic violation, of course. Under the Mendenhall definition, a pedestrian has been detained when police show a use of force or authority or order a person to stop or remain for questioning. For such a detention to be reasonable under the Fourth Amendment, the officer must have, articulable or be able to kind of state suspicion, okay, that the pedestrian may be involved in criminal activity. This means pretty much that the officer must be able to articulate or state exactly what the circumstances were that led him or her to suspect that that person may be involved in some type of criminal activity. Now, safety and control permitting, therefore, an officer should ordinarily attempt a consensual encounter, okay, by means of request before ordering somebody or through commands in order to detain them. And if the individual resists an encounter, the officer can articulate reasonable suspicion, then they can go ahead and do a detention. So an example of a couple of detentions that the courts have found, where police blocked the defendant's vehicle even though no red lights were used. So I pull up behind you and block your car. Where an officer pulled up behind a parked car, turned on a red light to signal the car not to pull away. A detention occurred because the red light means what? It means like stop, don't go. So you're telling somebody via the light not to go. Now, on the other hand, though, kind of unique, I thought I'd throw this in there. The use of a white spotlight, okay, for illumination of a vehicle does not create a detention. The court said that the white lights do not legally compel a person to stop. So, you know, the little spotlights on the side of the cars, if you shine those, say on a parked car, or as you're driving by, or you shine those on the car, that in itself is not a detention. Traffic stops, okay, a little bit different. The traffic stop, another example of a temporary detention, kind of what we were talking about before, also can be made on the basis of, you know, that word we just kind of mentioned, that articulable suspicion. Though many people often speak of probable cause for a car stop, you don't need probable cause for that. So that's a misnomer. That's not correct. This is not the proper legal standard under the Fourth Amendment. Okay, what makes a traffic stop a form of detention is the display of the red or blue lights or sirens, or show of authority, or a command by an officer for a motorist to pull over, since the reasonable person should know that he or she is not free to leave under those circumstances. Therefore, that creates the detention. Okay, so you only need that reasonable suspicion or articulable suspicion. You don't need probable cause to make a traffic stop. And to define what articulable suspicion means, so that way we can kind of get that out there. Unfortunately, there are few clear-cut formulas to determine whether facts and inferences amount to articulable suspicion to justify a detention. The court has held that a traffic violation, excuse me, or equipment defect is sufficient to justify a car stop. A wanted flyer for a suspect's vehicle or occupant was sufficient. And then there's some other factors that kind of contribute to suspicion. So stay with me and imagine yourself as a law enforcement officer, okay? And you're trying to find articulable suspicion, that you can articulate or state, okay, or explain when you see things in order to make a stop. So here's some other factors. Observations of the suspect's activity, time of day, nature of the location, the officer's knowledge of criminal activity in the area, information received by informants, or reasonable inferences that a trained and experienced officer would draw their attention. Now, we're going to talk about this in more detail, but think about that. So, observations of the suspect's activity. If you see somebody come out of a liquor store walking very, very fast, and you're walking a foot beat, and you're in uniform, and they've got a bag in their hand and a big fat jacket on, and right when they see you, they turn around and start running. Is that suspicious? It doesn't mean they're a criminal, but see, you can see how it would start to build up here. What about someone that came out from behind a commercial building where all the businesses are closed and it's 2 o'clock in the morning, time of day, and they're the only one around there? Could they be burglarizing? So time of day, nature of the location, your knowledge of criminal activity. What if it's an area known for drug sales, and someone's on the corner and you see them reach into their pocket and then lean into a car window and hand something to the driver, and the car drives off and the guy puts something back in his pocket? Does that look like a dope deal? So all of these things you can kind of build your suspicion on top of. So we're not going to spend, again, too much time, but I wanted you to kind of at least understand that. And then finally, length of detention. because we want to make sure we get that out there. Since a detention is by definition only a temporary seizure, it cannot be prolonged any longer than reasonably necessary to accomplish the purpose of the initial stop, okay? But if new facts come to light, then you can keep somebody there a little bit longer for investigative reasons. So there you have it. So we talked a little bit about this. I kind of got a little ahead of myself, but that's okay. So we're gonna just kind of brush right over this here. We talked about what a search was. It occurs when governmental action infringes an expectation of privacy that society is prepared to consider reasonable. We talked about a seizure of property occurs when there is some meaningful interference by the government with an individual's possessory interests of that property. A person has been seized within the meaning of the Fourth Amendment, where the government, by show of force or other assertion of official authority, communicates to somebody that they're not free to leave or disregard that police presence. Now, some things that are going to kind of come up here under encounters and detentions, under the court-created exclusionary rule, and we'll talk more about this later. Any evidence, okay, any evidence at all resulting from an unreasonable search or seizure is subject to exclusion from a defendant's trial. This means that every seizure, including both detentions and arrests, must be justified by a corresponding level of suspicion in order to be held constitutionally sound or reasonable for exclusionary rule purposes. And you're going to hear more and more about this thing that they call the exclusionary rule, but we'll kind of cross that bridge when we get there. So back to consensual encounters again, and this is I apologize, it's a long chapter, but we got to get this meaty stuff done. So when both the police and the person enter into a consensual contact, okay, so this is both. The police are not limited by the Constitution during this contact. Officers don't have to demonstrate meeting any legal standard whatsoever because it's consensual. No need to show that the officer has established reasonable suspicion or probable cause. The crime has been committed. It doesn't really matter. Officers asking a person if they would mind stepping aside, answering a few questions, that is a consensual encounter. Please remember as well, though, during a consensual encounter, the person is free to leave unless you, the officer, can meet the legal standard of reasonable suspicion or probable cause to seize them further. Okay, so you can build your case a little bit as you're talking to the person. Okay, the person does not have to talk with you or to you about an incident or possible crime if they don't want to. And under very narrow circumstances, a person may have to provide you with their name or identification. Now, some people also say, well, I don't have to give the officers my ID. Okay, that is not true. If you are asked to provide identification, you are to provide identification. And, you know, there are time limits again on, you know, encounters and detentions and things like that, but you are to have identification and to be able to present that upon request as well. Okay, so how about a detention? So we talked about that consensual encounter thing, so now let's kind of move on to detention. The Fourth Amendment of the U.S. Constitution uses the broader term known as seizure. A detention is a seizure and requires an officer to justify their government use of force by a legal standard, and that standard is less than probable cause. It's kind of worded reasonable suspicion. And this case, Terry versus Ohio, even though it was a case law way back in 1968, it certainly is one that I would suggest that you would look up and read, because you'll probably see that case again somewhere. But again, so reasonable suspicion to detain, probable cause to make an arrest. The officer must be able to articulate or explain their suspicion that the person may be involved in some type of criminal activity. And we already covered this, but the two most common examples of detention would be pedestrian stops and traffic stops. Traffic stops, again, temporary detention of a vehicle based on reasonable suspicion. That suspicion could be a vehicle code violation. You're speeding, you have a tail light out, whatever. Probable cause, or PC, is not a correct legal standard for such a stop, so that's not true. Okay, and what makes a traffic stop a form of a detention is the red, the blue lights, or the combination of both, or the sirens that honestly makes a reasonable person actually know that they are not free to continue, that they must pull over so the officer can have that conversation with them about whatever violation they observed. We talked about articulable suspicion. The Fourth Amendment of the U.S. Constitution requires searches or seizures to be reasonable. The officer must be able to articulate or explain those facts and inferences. And inferences are things that they see, okay, or other things that are out there that help justify their actions. Factors that may contribute to that suspicion are listed here below, and we've already talked about them. Your observations, time of day, nature, location, information received, and the inferences that you observe on somebody else. We talked about length of detentions. Detentions are temporary. They can't be really prolonged any longer than is reasonable unless, of course, you have new facts that become evident. Then you can extend the detention a little bit longer. If during your detention your suspicions are dispelled, you must release the person. Or if while you're during your detention, you produce what we know now as probable cause, then you can arrest the person. So Terry versus Ohio, super huge case. Very, very important that we know this case because it has a lot to do with pat-down searches, and I'm actually going to post a video for this chapter on the good, bad, and ugly versus Terry versus Ohio, relating to what they call out there called stop and frisk, a technique used by the City of New York Police Department that kind of got a lot of controversy attached to it. By searching people for guns and things, but I'll put the good part and the negative part on in the content folder, and you can take a look at it, and then you can maybe even comment about what you think. But Terry versus Ohio, 1968, during a temporary detention, an officer may conduct a cursory or what they call a pat-down search. The search, however, is limited to the outer clothing of an individual. The officer must have articulable suspicion, okay, we've heard that the person is armed and or dangerous. Now, an officer may use this same principle to permit a cursory search of a person's passenger compartment of their vehicle during a traffic stop as well. I'm not going to spend the entire time going through that Terry case because honestly, it will just take quite a long time. So I'm going to have you look that case up, and we'll talk a little bit more about it as we move on. So vehicles and occupants. So we talked about stopping people and doing the pat down search and things like that. But now let's talk a little bit about vehicles and occupants and what you can do when it comes to that. So during a lawful traffic stop, police are permitted to routinely order all occupants out of a vehicle and have them remain in a neutral location. This order need not be justified by any particular suspicion of criminal activity. The officers also have the right to inspect the VIN number, that vehicle identification number in the car, which is usually in the door frame or up on the dashboard on the left-hand side of the vehicle, kind of at the area where the dashboard meets the bottom of the window. The officer also has the right to retrieve a person's driver's license and or registration from the vehicle. So you do have certain rights when you are making a traffic stop out there, and some of these people have been kind of given misinformation where the officer can't have everybody get out of the car. Well, that's simply not true. They can have everyone get out of a vehicle and have them remain in a neutral location. Now, one thing I'll kind of throw in there, and then I'm going to move on. A lot of times, or in the past, maybe you've seen an officer stopping a car, the car stopped, the officer's writing a ticket or writing in his notebook, and you see 2 or 3 people seated on the curb. Now, typically, okay, the officer has the right to have people get out of the vehicle, as we've already talked about, put them in a neutral location for their safety. Now, that sometimes officers will have individuals sit on the curb not because they're trying to demean them, okay, but what they're trying to do is put those individuals at a position of a lesser advantage should they decide to excuse me, run, fight, or what have you. If you're sitting down on the curb and let's say your feet are crossed out in front of you, it is a lot more difficult for you to stand up and become involved in an altercation than if the officer was standing up talking to 3 people standing up. Does that make sense? Again, these are things that I'm just kind of throwing out there so you can understand sometimes why officers are kind of doing what they do. So now, let's move on. And I'm not going to spend a lot of time on this. So these are some sections where I'm going to kind of go through pretty quick. Okay, so peace officers defined. You can see the section 830.1 defines a peace officer. A peace officer includes all of these that are listed below. And you can look at that in your textbook because there's a lot of other things in the chapter I want to get to. Peace officer status, you can see 830.2 -10, the primary duty or authority. These particular entities have peace officer status as well. So highway patrol, university or state college police, correctional, probation, parole, reserve officers, arson investigators, and then some down below, forestry, DMV, ABC, and what have you. So just kind of give you an idea of some of the officer status. Kind of continuing on, peace officers are required to wear a badge or a nameplate, and there's a section for that goes along 830.10, and the reason is for identification purposes, the badge or the number or the name tag with the name. A peace officer is in fact an officer 24 hours a day, may be called upon on or off duty, and that was in a memorandum in an opinion way back in 1960 by the Attorney General at the time. Members of a police department are authorized to carry concealed firearms or other weapons inside or outside of the jurisdiction for which they are employed. So you can have your firearm, even if you work in, let's say, Rialto, you can still have your firearm in Redlands or another city. So that jurisdictional boundary doesn't really count when it comes to sworn law enforcement officers. So now we're going to move into some of the amendments, a couple of the super important ones. Now, they're all important, so don't let me kind of say the wrong thing that, hey, none of them are important, but there are some that are going to be a lot more applicable to what you're going to be dealing with versus some others. So the Fourth Amendment, okay, and you should have probably already looked at that PowerPoint that I posted on all the amendments. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants, okay, be issued but upon probable cause, just like an arrest. So you have to have probable cause for arrest. We also have probable cause for a warrant, okay? Supported by oath or affirmation, meaning the officer swearing under oath, and particularly describing the place to be searched and the persons or things to be seized. So this is geared, talking about the Fourth Amendment, illegal search and seizure for persons, and for when you talk about warrants for homes. Okay. So arrests without warrants. So not officers don't always make arrests without warrants. As a matter of fact, the majority of arrests by law enforcement officers are made without a warrant. And these arrests must be based on the Fourth Amendment standard of probable cause. We've kind of gone over that. And the accused must be taken before a magistrate or a judge without unnecessary delay. And typically that is 48 hours. So in California, if we make an arrest, we have to have our case to the DA and everything has to be ready to go within 48 hours, or that person can and actually will be released pending more investigation on the case or whatever. So, but all your arrests must be, based on that standard of probable cause. Now, to arrest a person in their home, okay, because it's different than when they're walking on the street or driving a car a little bit, because their home is their castle, if you will, and you have the right to privacy in there, right? So to arrest a person in their home, an officer must do so under a couple of different ways. One would be by a warrant. So you would get a warrant to go arrest somebody in the home. The second would be pursuant to a probation or parole condition. So you have conditions of parole or probation that might mean that someone can come in and search your home, and then you could get arrested if you had illegal items in there or what have you. Another one is under what they call exigent circumstances or emergency circumstances, meaning that a warrantless arrest can be made, or entry, if you will, can be made into a home if there is some type of emergency. Okay, so such urgent things include things like life-threatening or dangerous crimes in progress, such as like murder, robbery, rape, aggravated assault, kidnapping, things like that. So in other words, if a suspect is already inside of a home and the police arrive to arrest him, they must have a warrant or the probation or parole search or exigent circumstances or consent. Okay, so if I ask for consent to go into your home and you allow me in, then that is okay as well. Okay, one other thing to kind of throw out there, if the police contact a subject outside the home, inform them that they're under arrest and he tries to flee, or she, because it could be a he or a she, and they go into the home, that person may be lawfully pursued into the home by law enforcement officers and taken into custody. However, if they're going to search the house, they're going to need a warrant, probation or parole conditions, or consent. And I'm hoping that most of that kind of outlines arrests without warrants. So police officers' powers to arrest, they have powers to arrest listed in the Penal Code 836 subsection A. The officer can make an arrest under these circumstances when the officer has probable cause that a public offense has been committed in their presence. So if you believe a crime's occurred, there you go. When a person to be arrested has committed a felony, although not in the officer's presence. And the last, when the officer has probable cause to believe that a person to be arrested has committed a felony, whether or not the felony has in fact been committed. So here's an example of the second one. The first one's easy. When an officer has probable cause to believe that a public offense is occurring in their presence. You're seeing it, you believe it's happening, you make the arrest. When a person to be arrested has committed a felony, though not in your presence. So an hour, let's say that you get a robbery call at a liquor store and the money was taken in a blue Ziploc bag about the size of a small purse, and the person was described as a Caucasian male wearing a black beanie and last seen running through the alley. 45 minutes goes by and you're in the neighborhood looking for somebody and you see this person that matches the description. They have a black beanie on and they're holding a blue bag and they're running. Okay. Look at number 2. When a person to be arrested has committed a felony, although not in the presence. So would you have enough suspicion to detain that person for investigation? Sure. So you would detain them. Let's say you find money in the bag. You believe he's the suspect. Now you have probable cause, but the crime didn't occur in your presence, right? But you have evidence to show that the person may be involved in the crime. So you have enough there to arrest that person or to detain that person and then subsequently arrest them. And then the last one is when the officer has probable cause to believe that the person to be arrested has committed a felony, whether or not a felony has been committed. What if you pull over a car? Okay, I'm just going to quickly give you an example. And inside the car is a ski mask, a handgun, a bloody knife, and a bunch of money. And what do you think? Do you think maybe that person has committed a crime? What if it turns out that it really wasn't a crime, that for some other reason the knife was bloody? I don't know what it would be, but let's just say there was no crime committed. You still lawfully had enough probable cause to believe that they were involved in a crime, a felony, a stabbing, an assault, whatever, even though it actually didn't happen. Okay, so you could still make an arrest based on that. Now, prosecution, of course, would be different. So powers of arrest kind of continuing. So we can see here, these are just some terms. Officer's presence, we've got the define, relates to an officer's senses, sight, hearing, taste, touch, smell. Public offense includes felonies, misdemeanors, infractions. And again, no civil liability, okay, or cause of action against an officer within the scope of his or her authority. So you're probably wondering, well, what if they make an arrest and it really isn't it turns out not to be a crime? Well, if they're doing it within their scope of their authority and they're not doing it for any other reason other than that, then they're okay. If they're doing it just to get even with somebody or something different, that's a different story. But if they're operating within the scope and course of their employment and they truly believe that a crime has been committed, then they have the authority to make an arrest, and that should be pretty good. Now, the first one here, real quick, also officer's presence. You can build up your ability to form articulable suspicion, to detain, and even probable cause based on senses. Okay, so let's say you hear a gunshot and you look in the direction of the gunshot and you see somebody running, but you don't see anybody shooting. Would you maybe believe that that person was possibly involved in the shooting because maybe they shot and then they ran? Or how about you pull a car over and you smell alcohol reeking out of the car? That's the smell. Okay, or touch. Let's say you go to pat somebody down and in the area of their waistband where people are known to carry guns, you squeeze with your hand right there on the outside of their clothing and you feel a hard metal object that feels like a gun. Is that enough to articulate? The answer would be yes to all of those, and would give you enough to detain and subsequently arrest. So these are things that, again, that you need to kind of read in your textbook here so we can fill in some of these blanks as we're going along. Okay, so duty following an arrest. So now we made the arrest. We know where our police powers come from. We know what we can kind of do. After an arrest, an officer shall take the arrested person before a magistrate without delay. Typically, we need to get our case filed within 48 hours. A peace officer may release a person from custody, any person arrested without a warrant, whenever. Okay, so first one, there are insufficient grounds for making a criminal complaint. The person was arrested for intoxication only. The person was arrested for being under the influence of a controlled substance or drug, and the person is delivered to a hospital. And again, at the bottom, warrantless arrests, which is the majority of the ones that we do, must be reviewed, okay, for probable cause within that 48-hour period. So the way it works, let's say I arrest you for burglary and I take you over to the jail and drop you off. I have to write what they call a probable cause declaration in California. It's kind of a summary, very quick summary of what happened, and I send that over to the court, and I have to have, or to the jail, and there's a court officer over at the jail, and basically they will review that probable cause within 48 hours. If I don't meet the level of probable cause necessary, they will release that person, and I'll have to do some more work on the case in order to get the person, a case filed on them. But if I do meet the clock, then the person will end up going to court, be arraigned, have a preliminary hearing, bail will be set, and all those other things that we'll talk about later on when we talk more about the court system itself. Now, private person's arrests, kind of a huge issue. Okay, Penal Code 837 says a private person may arrest or detain another for kind of like almost what law enforcement can do, a little bit different for a public offense committed or attempted in their presence, when a person arrested has committed a felony, although not in his or her presence, and when a felony has in fact been committed and the person has reasonable cause for believing the person arrested to have committed it. So if you see somebody running out of your garage with your weed eater or whatever, and you decide to detain them for law enforcement, you can make a private person's arrest. If you are assaulted by your neighbor and law enforcement arrives, and you can make a private person's arrest. So these are things that you actually can do. Now, you're not a law enforcement officer, okay? So there's a little bit of a difference there. Well, there's quite a bit of difference actually, but as a private person, you do have the right to make arrests, private person's arrests, under these circumstances that I'm kind of telling you. Okay. And I know I'm going through it quick, but we have to kind of get through quite a bit. So under private person's arrest, kind of a little bit more information: domestic violence calls. Officers are required to make a good faith effort to inform the victim of their right to make a private person arrest. There's a couple of definitions in there that talks about what presence is. Under a private person arrest, you're not justified to use lethal force in making arrests for crimes against property. After an arrest, the private person must take the person before a magistrate or peace officer, and typically law enforcement will show up without unnecessary delay. Unnecessary delay is what it really should be. So, duty of officers to receive an arrest. Penal Code 142 basically says any peace officer with the authority to arrest who willfully refuses to receive or arrest a person is guilty of a crime. This section does not apply to arrests made by private persons. And the section's 142 subsection C. And to avoid civil liability, courts have insisted that probable cause support any arrest made or accepted by a peace officer, including those made by a private person. So you have a section here that says any peace officer with authority to arrest who willfully refuses to receive or arrest a person is guilty of a crime. But you have to be able to still meet the elements of the crime. Okay, so you're not going to get sued. What you don't want to do is have some private person say, hey, my neighbor assaulted me. You have absolutely no evidence to that, and you end up arresting a person and it never happened. Does that make sense? So here the courts are saying, hey, we're going to help you out a little bit. So to avoid that liability, the courts are insisting that probable cause support any arrest made or accepted by a peace officer, including those made by a private person. Okay, so if you believe somebody is lying and you have no evidence to the contrary, then you don't have to accept that arrest. Now, you may want to send the report to the district attorney's office, have them review it, and if they determine that it's okay and they want to file it, that's great. But you can't always believe everybody's statements on everything that is said. But you do have somewhat of an basically a requirement to arrest when you can. Misdemeanor citations. An officer may use a written notice to appear, which is basically a ticket, at pretty much any time under some circumstances, for any misdemeanor offense which he has reasonable cause to believe the person to be arrested has committed, or for any misdemeanor offense in which a private person made the arrest and delivered the arrested person to the officer. So typically the citation release procedure doesn't apply to violent or serious felonies, nor to crimes involving like witness intimidation, criminal threats, family abuse, stalking, and things like that. But if it's a petty theft case, let's say 488 of the Penal Code, so petty theft, somebody went in, stole something from a grocery store, the officer can use a written notice to appear as a misdemeanor citation to release that person on a promise to appear in court, and then they don't have to end up booking the person. So Now let's get into probable cause, because this is going to probably eat up the next 15 minutes, and I'm going to try to get this done within 60 minutes, and I don't know if I'm going to be able to, but I'm gonna give it my best shot. So let me kind of look forward here to try to see how much more we have to go. Well, we actually have quite a bit. So I think what I might do, well, now I'm going to go for it. So probable cause to arrest. Under the test of the Fourth Amendment, reasonableness, an arrest must be based on probable cause, okay? And probable cause defined is a state of facts as would lead a person of ordinary care and prudence to believe and conscientiously entertain an honest and strong suspicion that a person is guilty of a crime. And the courts look at two different aspects of reasonableness. So probable cause to believe that a crime was prima facie committed based on the corpus delicti, meaning like on its face, prima facie, or probable cause to believe that the person arrested is the person who in fact committed the crime. So, under that test of the Fourth Amendment, again, reasonableness, an arrest must be based on that probable cause standard. And I just kind of gave you what the definition of that is. Probable cause defined, it's been judicially defined on a lot of different occasions since 1984, but it kind of goes like this. Such a state of facts as would lead a person of ordinary care and prudence to believe and conscientiously entertain an honest and strong suspicion that the person is guilty of a crime. So that's kind of that probable cause to arrest. So an example could be for probable cause, a driver weaving and speeding would constitute that articulable suspicion that we talked about that would justify a traffic stop or maybe even a detention. Well, it would justify a detention. Once an officer had added this degree of suspicion to the driver's intoxicated appearance, admission to drinking, and poor performance on the field sobriety test, the initial suspicion would have grown into sufficient probable cause to support the fact the person was driving under the influence. Does that make sense? So you kind of build your case, if you will, your probable cause to make an arrest. So in making a determination of probable cause, the relevant inquiry is not whether particular conduct is, innocent or guilty, but the degree of suspicion that is attached to particular types of non-criminal acts. Specific fact, not hunches, are the requirement of the probable cause standard. So probable cause is measured objectively. An arrest may be upheld on one ground even if the arresting officer relied on another unsupportable ground. So, it's a case, Illinois versus Gates, which kind of gives you some probable cause factors, if you will. And there are probable cause factors, just like there were those articulable suspicion factors. If you remember, we kind of went over those. Well, here are some probable cause factors. Now, the difference between articulable suspicion and probable cause is not the nature of the underlying information, but in the amount. Okay, and here are some factors of establishing probable cause: the suspect's activity, attempt to hide or concealment, flight, manner of dress, location, time of day or night, prior criminal record, number of suspects, information or informant information, the suspect's appearance, patterns of activity, or facts gained by officers. These are all probable cause factors. Is that kind of making sense? So the amount of all of these together. So very quickly, let's talk about entrapment. Let me back up just real quick here for a second before we hit entrapment. And again, I don't want to spend too much time, but if you look on page 99 in your book, there's more probable cause factors. Okay, so in like the middle of the page, it talks about probable cause factors, the kinds of factors previously mentioned in that articulable suspicion, but they list quite a few more. And that Illinois versus Gates case is also referenced in there. So there are many, many factors that fall in there. I just gave you some. Okay, so now entrapment. So what is entrapment, and what does it really kind of mean? So Black's Law Dictionary defines entrapment as an act by the police of inducing a person to commit a crime not contemplated by the suspect for the purpose of prosecuting him. In one of the leading cases in California, the court stated, the law does not tolerate a person, particularly a law enforcement officer, generating in the mind of a person who is innocent of any criminal purpose the original intent to commit a crime, entrapping such person into the commission of a crime which he would have committed or even contemplated but for such inducement. Now, I know that's hard to swallow. I got a problem with this too, because people commit crimes pretty much because they want to, and I know there's other reasons, but how would you entrap somebody to commit a crime? Well, let's look at it a little bit more focused. So entrapment, an act by the police of inducing a person to commit a crime not contemplated by the suspect. So let me ask you this. We've had a lot of thefts in the area. So we decide to park a bicycle out in public, and somebody walks by, gets on the bike, and rides away. Is that entrapment? I'm not going to tell you the answer to that yet. Okay, how about this one? We've had a lot of auto burglaries in the area. So we get a car that's owned by the police department, a regular car, not a black and white car, just a regular car. We park it. On the front seat, we put a brand new Dell laptop computer, and then we lock all the windows and doors and we leave. Somebody comes by, looks inside, breaks the window and takes it. Is that entrapment? We'll talk more later on. The answer to the second one is no. Anyway, but we'll talk about that. So the reason for allowing entrapment as a defense is to do what? Well, it's to deter police misconduct for setting somebody up. And I suppose there are occasions where this really could take place. The defense in these cases should focus on police conduct and not the defendant's conduct when they use this as a defense. Now, the current test is now whether the conduct of the law enforcement officer is likely to induce a normal law-abiding person to commit the offense. So I get it. If you're walking down the street and there's a $100 bill on the ground, it doesn't belong to you, and you pick it up off somebody's lawn and keep on walking, is that entrapment? If the officers are the ones that put it there? Read the entrapment section. It's cool to kind of figure out, some of these cases and what it really means to kind of entrap somebody. And I just kind of gave you the current entrapment test and the information about that. A little bit more, officers may set reasonable traps. Oh, so we can a little bit in an effort to apprehend criminals. Kind of like what I told you about the laptop in the car, right? Officers may provide opportunity for a crime's commission and may use decoys to participate in the crime. So the use of a little bit of deception is allowed. Use of informants is essential to detect and gather evidence in a crime. So informants may include the following list of individuals that you have there before you: minors between a certain age under a court order, in custody informants. You're going to have to disclose that to the jury. And then informants wired for sound. We can wire people up to go in and talk to somebody to help get your information. So setting traps, we can set reasonable traps in an effort to catch criminals. This is best illustrated by an early California case where a constable disguised himself kind of as a drunk lying in an alley in an effort to apprehend suspects who were basically rolling drunks or beating them up or taking their wallets. The court said there's no entrapment where an officer disguises himself, fakes being a drunk, and makes no objection when money is taken from his person and the person is later arrested. Well, how about a decoy? When officers of the law are informed that a person intends to commit a crime against the property of another person, law enforcement permits them to afford opportunities for its commission, and to lay traps which may result in the detection of the offender. To this end, a decoy may pretend to be a participant in the crime. The decoy may be present with the suspect at the time the crime has committed. So you can actually use decoys. What about deception? The courts have held, for example, that the loaning of a truck to the defendants by a police officer to facilitate the commission of a burglary is not entrapment, even though the officer knew from his conversation that they intended to commit a crime. So we have a little bit of wiggle room in here, but there are things that do come up, and there are cases of entrapment. So I'm not going to pretend that it never does happen. So accomplishing the arrest. So we've got all that. And again, read page 101 in your textbook, because we're coming up on 60 minutes here, and look at some of the things in there, like use of informants and surreptitious surveillance and informants wired for sound. So those are a couple of real good things that you really kind of want to look at. So now accomplishing the arrest. Well, how do we do that? It's made by an actual restraint, like we grab your hands and put them behind your back or whatever, or submission into custody, meaning you give up and we're going to put you into custody. Person may use whatever force may be necessary for the arrest as long as such means are reasonable. Okay. Person is never justified in using deadly force on one guilty of a misdemeanor in order to effect the arrest unless in self-defense or to counter deadly force. And what they call de facto arrests. If there is no probable cause to arrest, the arrest is unconstitutional. Officers and their agencies will assume some type of liability on that. Okay, so that's that kind of de facto arrest. So I'll give you kind of an example. Even though an officer does not tell a suspect he or she is under arrest, and even if the officer does not subjectively consider the person to be under arrest, if the subject is subjected to restraints on the liberty that are the functional equivalent of a formal arrest, the courts may find that an arrest actually has occurred. So an example here, where suspects were apprehended at their homes or in some public place, were handcuffed and transported in police vehicles to the police station and were detained at the station against their will. Numerous decisions have considered this to be a de facto arrest if there was no PC to arrest in the first place. Make sense? Okay. It should. Accomplishing the arrest a little bit further. Section 841 of the Penal Code says the person making the arrest must inform the person being arrested the intent to arrest, the cause of the arrest, and the authority to arrest. Now, it doesn't mean that, if I take you into custody, I have to say, by the way, you are under arrest, or I'm intending to arrest you, so I'm going to arrest you now. I'm going to put the handcuffs on you. But what this is basically saying is that at some point, they're going to need to know why they were arrested, what they were arrested for. Okay, but this 841 section is, in fact, very specific, and they do need to know that they are going to be placed under arrest, the cause of the arrest, and the authority. But some of those things are kind of by inference. Okay, and here's an example. If you just robbed a store and you're running from me and I'm the officer in uniform and I'm chasing you, can you already see that my intention is to arrest you, and the cause of the arrest will be you running after you did the robbery, and the authority to arrest would be my uniform and my handcuffs being placed on you? So, again, you have to read some of these other sections in here to really kind of get a good understanding of that. Penal Code Section 835A, any peace officer who has reasonable cause to believe that the person to be arrested has committed a public offense may use reasonable force to do these three different things: effect the arrest, prevent escape, or overcome resistance. And we'll talk more about use of force and things like that kind of down the line, but we are going to hit resisting arrest real quick. So Penal Code 834A, if a person has knowledge, or by the exercise of reasonable care should have knowledge that he or she is being arrested by a police officer, It is the duty of that person to refrain from using force or any weapon to resist. This is part of the issue right now in law enforcement as a whole, where people are being told, if I don't agree with the officer taking me into custody, I don't have to let him take me into custody. That is not true. I just read you the section. Okay, the time to dispute an arrest or a violation of the Fourth Amendment, Sixth Amendment, Fifth Amendment isn't at the time when you're being arrested. There are mechanisms in place afterwards. So listen to the section again. If a person has knowledge, meaning I'm telling you you're under arrest, dude, or by the exercise of reasonable care should have knowledge that he or she is being arrested. I have my handcuffs in my hand and I'm grabbing your arm. It is the duty of you, that person, to refrain from using force or any weapon to resist. Okay, it's the law. Along with that, 148.9 says it is a misdemeanor to give false identification to a police officer when lawfully detained, to evade the process of the court or to evade proper identification. So if you lie about your name or what have you, you can get arrested for that. But 834A is very important. So I think that that's what a lot of people are always told. Hey, I don't agree with what you're doing, officer, therefore I'm not submitting to arrest. Well, the section says you can't do that. And again, there are lawful mechanisms in place. And I'm not going to say that every police officer out there is correct either, okay, in what they're doing. But there are mechanisms and ways to deal with this, not just, on the onset, just kind of resisting arrest. So let's talk a little bit more. Another section that falls under resisting arrest. Excuse me. Every person who willfully resists, delays, or obstructs any public officer, police officer, or emergency medical technician in the performance of their duty, his or her duty, when no other punishment is prescribed, is punished by fine, jail. So 148 of the Penal Code is basically that resisting arrest section. Every person who willfully resists, delays, or obstructs any public officer during the course of their duties. It's very simple, and a lot of people don't understand this section either. It is not a violation of this section for a person to photograph or make an audio or video recording of an officer. That's placed in there simply because now with phones and officer body-worn cameras and everything going on with video, for everyone to understand, hey, it's not a violation. You can record, okay, an audio or video recording of an officer. You can. It's not a violation of something. And then finally, we're going to try to finish up here real quick. Miranda rights, super duper important as well. I'll see if I can, I'll see if I can finish it all in there. I may not be able to. Well, we'll see. Some of this you may have to kind of get on your own. The Miranda admonishment, the Fifth Amendment, no person shall be compelled in any criminal case to be a witness against himself. In that famous Miranda case that you should read, Miranda versus Arizona, the Supreme Court held that the compulsion is inherent or built in the process of custodial interrogation. The stress of a police-dominated atmosphere tends to undermine a person's free will to speak. Prosecutors may not use any statement made by a criminal defendant to prove guilt resulting from custodial interrogation. So really what that means is that when you, well, let me back up and I'll make it kind of simple. The Fifth Amendment to the United States Constitution includes a provision that says no person shall be compelled in any criminal case to be a witness against themselves. So you don't have to testify against yourself. In a 5-4 1966 landmark decision, Miranda versus Arizona, the U.S. Supreme Court held that compulsion is kind of built into the process of custodial interrogation because some people feel intimidated. They've got a law enforcement officer, he's got a gun, a badge, a hat, a jacket, whatever, and they feel like they have to say something, but they don't have to. The court reasoned that whenever a person is arrested and held in isolation by police, the stress of that police-dominated atmosphere and the knowledge that one is under arrest tends to kind of undermine the person's free will, meaning that I need you to talk so and so, and you have to talk. Well, the truth is that you really don't have to. And any statement given under any circumstances other than ones that where you are properly advised of your Miranda rights, any compelled statements is going to be a violation of the Fifth Amendment, and that statement is going to be kind of throwing out. So having reached this conclusion, the Supreme Court established a judicial exclusionary rule under the Fifth Amendment, as it was in the Fourth Amendment. For search and seizure, the court declared that the prosecution could not use any statement made by a criminal defendant to prove guilt, whether incriminating or not, resulting from custodial interrogation, unless adequate safeguards were taken to neutralize that inherent compulsion. And physical evidence discovered by interrogation lacking Miranda compliance is not made inadmissible by Miranda as well. So the Miranda rights, and it's, the thing that you've probably always heard, in some of the movies that you watch. You have the right to remain silent. Anything you say can and will be used against you in court. You have the right to you have the right to the presence of an attorney before and during any questioning. And if you cannot afford to hire an attorney, one will be appointed to you free of charge before any questioning. So that's kind of like the Miranda waiver, because you don't have to incriminate yourself. And that's really what that Miranda versus Arizona case stands for. Here it is kind of, again, very quickly, and we'll move through it, but these are the procedures for the admonishment. A lot of times now there might be a form that goes along with the Miranda waiver so the person can sign it, so you have some type of evidence that they understood their rights. And a lot of times officers may ask them, hey, a question afterwards to put in there. So it would go like this: you have the right to remain silent. Do you understand that? So that way you know that they understand. So steps following the admonishment before the prosecution can offer a suspect's response to custodial interrogation into evidence. The prosecutor has the burden of proving the suspect was timely and appropriately advised of their rights, understood their rights, and here's the biggie: voluntarily waived their rights. Okay, voluntarily, not coerced. If the suspect invokes their rights, meaning they don't want to talk, any custodial statement obtained thereafter will be inadmissible unless the suspect initiates further discussion and waiver of their rights. So two things have to actually come into play before you really need to read somebody their Miranda rights, although you're taught a lot of times to read anybody that's arrested. There needs to be the custody, okay, and then there needs to be the interrogation. So if someone's not in custody and you call them to the station and you want to talk to them and they're free to leave and blah blah blah, you can talk to them and you don't have to read them their rights. Custody and interrogation are the two pieces that fit together to where Miranda is really, where you have to do that. And in your textbook, it talks about what constitutes interrogation and what constitutes custody and what have you. So when admonishment is required, we'll talk a little bit more, and I just kind of went over it. The Miranda admonishment is only required when these two elements are present: custody and interrogation. Neither custody nor interrogation alone will trigger the need for Miranda, although you can if you want. It is the only combination of custody and interrogation together that creates that need for that Miranda warning. So what constitutes custody? Really quick, the ultimate inquiry for custody is whether the person is under formal arrest or restraint equal to formal arrest, and there's a couple of cases there for you to look at as well. The critical factor for custody is whether a reasonable person in the suspect's position would not have felt that he was under arrest at the time the interrogation occurred. And I'm going through this pretty quick because I'm trying to make sure that we can get this whole thing done. What constitutes interrogation? The term interrogation under Miranda refers not only to express questioning, but police words or action that are inherently likely to elicit an incriminating response from the suspect. Now, typical booking questions like, how tall are you? How much do you weigh? Do you have any medical issues? That's different. So typical booking questions would not be subject to Miranda warning or the exclusionary rule or any exclusionary provisions, only what I just kind of talked about above. Something called independent state grounds. Very quickly, People versus May, 1988. The truth and evidence provision of Proposition 8 rescinds the state-grounded exclusionary rule. Violations of Miranda that are inconsistent with the state standards will not be excluded from a criminal court proceeding if they meet federal rules. And basically they're saying that, well, maybe not all statements are going to be thrown out if these violations of Miranda, again, are inconsistent with that state standard. And if they meet the federal rules, then maybe they can kind of be in. Some of the other rules, we're not going to spend a lot of time on this, but it's not desirable to over Mirandize. A Miranda warning is not required before every single custodial interrogation. For juveniles, Welfare and Institution Code 625 created a statutory duty by police to advise a minor of certain rights consistent with the Fifth and Sixth Amendment constitutional rights when a minor is taken into custody. Regardless of Miranda, a suspect's volunteered statement is always admissible. So if somebody blurts something out and you didn't say anything to them, you can use that statement. Also, the Sixth Amendment right to counsel will be violated if police initiate interrogation of an accused person after he or she has been indicted or arraigned on a case and has requested an attorney. And that's another reason and another big part of the Miranda case. He wasn't advised of his rights during his case. He didn't know that he had the right to remain silent, and he wasn't afforded certain rights. That was kind of one of the real big issues with that Miranda case. So finishing up real quick again, and we're not going to take a lot of time on this one. Arrest pursuant to a warrant. In order to secure arrest warrants. Okay, so before it was arrest without warrants, now we've got them. In order to secure arrest warrants, the courts require an affidavit to accompany the complaint. Penal Code 817 says the courts have held that a non-consensual, non-emergency entry into a home to make an arrest requires a warrant. So if it's non-consent and non-emergency, in order to arrest somebody in a home, okay, you need a warrant, and that's People versus Ramey, and that's a very good case for you to look at. Now, warrant service, you can serve a felony warrant anytime, day or night. Misdemeanor or infraction cannot be made between 10 p.m. and 6 a.m. unless these conditions down here are all met. And again, I'm not going to spend a whole lot of time on that as well. Escape, pursuit, and retaking, and sorry, that pursuit is spelled wrong. I just kind of noticed that. Escape. A person who has knowingly been lawfully arrested by a peace officer commits a misdemeanor by escaping or attempting to escape, becomes a wobbler if force or violence causes serious bodily injury to the police officer. Fresh pursuit, these are some meanings here, means close pursuit or is sometimes called hot pursuit of a suspect by a police officer. And then bail, fugitive recovery, a bail agent who apprehends fugitive. Now, posse comitatus, kind of an interesting word. Power of the county, when a sheriff or other public officer, police officer is authorized to execute this process, may command as many able-bodied individuals to help that officer as he or she may deem necessary in overcoming the resistance of an attacker, what have you, or in seizing or arresting or confining persons that are resisting. So Penal Code 723. I'm not going to spend a lot of time on threatened offenses. I'll let you read that yourself. And then the same thing with diplomatic immunity. I'm going to kind of skip through that just for the sake of time. But it doesn't cover this diplomatic immunity thing. It doesn't cover traffic tickets, nor police intervention to keep the peace or prevent serious crimes and things like that. And the arrested person's rights, people do have rights. Don't forget that, because that's why we have all the amendments. Within 3 hours after having been booked, a person has the right to make at least 3 completed phone calls. Penal Code 851.5, unless otherwise released, must be taken before a magistrate without unnecessary delay. We've kind of talked about that. And you have the right, as an arrested individual, you have the right to visitation by an attorney upon request. So all of these things are those rights. Typical defenses to civil actions brought against police officers. These are things that, when people sue law enforcement, so these typical defenses: probable cause for the arrest, reasonable force in effecting the arrest, self-defense, and coercive interrogation claims. These are things that typically come out in the civil liability end. So wow, I did make it a little bit over. We're running probably about 75 minutes, so I apologize for that. There's a lot in there. I'll post some extra videos. That's really it. If you have any questions, please hit the discussion board, and I'd be more than happy to answer them. Other than that, that's it for this Chapter 7 lecture, and I'll talk to you soon.